Question: what does the caution given in the police interview mean? This video is a very important one to understand because failing to understand the caution has possible serious consequences for you. When you're interviewed by the officer at the police station because you're suspected of committing an offence or offences, the interviewing officer will start the interview by giving you the caution, then proceed to explain the caution to you, and then ask you to confirm you understand the caution. Giving and explaining the caution and confirming you understand the caution is vital for the police, because if the officer does not give the caution at the beginning of the interview, or if the officer does not explain the caution, or you say you don't understand the caution, or you don't confirm whether you do understand the caution because you say no comment or remain silent, then anything you say, that is any evidence from the interview, is potentially inadmissible if the case proceeds to a trial. The caution given by the officer at the beginning of the interview is: you do not have to say anything, but it may harm your defence if you do not mention, when questioned, something which you later rely on in court. Anything you do say may be given in evidence. Notice the caution is made up of three parts: a right, a warning, and what can happen to the recording. The first part of the caution is the right. You do not have to say anything. This means that even though the interviewing officer will be asking you questions, you don't have to answer them. In other words, you have a right to remain silent or say no comment. The second part of the caution is the warning, but it may harm your defence if you do not mention, when questioned, something which you later rely on in court. This means that if the case goes to court and you tell the court something that you did not mention during the police interview, that you could have told the interviewing officer, e.g. you weren't there or you were acting in self-defence, then the court can draw its own conclusions from you doing this. Such conclusions could be that the facts or defence you're relying on at the trial, which you didn't mention in the police interview, e.g. you weren't there or you're acting in self-defence, are a recent fabrication, a lie, and made up. In other words, when given the opportunity to put forward an account, mention an important fact or a defence during the police interview, but you didn't because you said no comment or remained silent, then an adverse inference may be drawn from your no comment or silence. Put in another way, the middle part of the caution is a warning. That is, sometimes, not always, remaining silent or saying no comment may be seen as a sign of guilt by a judge or jury. The final part of the caution is about what can happen to the police interview recording. Anything you do say may be given in evidence. This means that if the case goes to court, the court can be told about anything you said during the interview. In other words, play back or read a transcript of what you said or didn't say during the interview. It's very important that your lawyer explains the caution to you before the police interview, advises you whether you should confirm whether you understand the caution in the police interview, and advise you about the possible consequences of answering police questions, and advise you about the possible consequences of not answering police questions and saying no comment or remaining silent. Feel free to comment, follow, like, and share.